is this going to be a civil or criminal action? You got to ask that. You got to ask. I see people try to do this and they leave this part out. You got to ask them, is this going to be a civil or criminal action? The reason for that is that there's only 2 criminal jurisdictions in the Constitution, but there are 3 jurisdictions. So we need to narrow it down. So when you ask, is it criminal or civil, and they say criminal, we know it's not equity because there's no criminal aspect to equity. So that only leaves common law, maritime admiralty. So it goes on, it says, so he's going to say, is this going to be civil or criminal? If the judge answers that it is a civil action, not likely, then you must immediately object and move for a dismissal. The reason here is that you are now in the wrong court. The state cannot bring a case against you and judge its own case. It cannot be both party to and judge of their own action. On the other hand, if the judge answers that it is a criminal action, most likely, then you can make the following announcement on the record. Thank you, Your Honor. Let the record of this court then show that this action against John Henry Doe is a criminal action. Now I have another question you answer, Your Honor. Your Honor, the Constitution grants this court 2 different criminal jurisdictions. One is a criminal jurisdiction under the common law, and the other is a criminal action that constitutes a condition of contract on the criminal aspects of a colorable admiralty jurisdiction. Under which of these 2 jurisdictions does this court intend to try this criminal action? Not wanting to answer, they never do. They don't want to answer it. The judge might just dismiss your case now, but most will still try to go ahead with it. The only choices now are to admit to which jurisdiction applies or to avoid answering. Get an answer. If the common law criminal jurisdiction were to be declared, then you win by default of no sworn complaint by an injured party, because you got to have an injured party under the common law. So the judge don't want to answer the question. The judge might just dismiss the case now, but most will still try to go ahead with it. The only choice now are to admit to which jurisdiction applies or to avoid answering. Get an answer. They're going to do everything they can to slip and slide and try to give you. I know a judge one time, he gave me a bullshit answer. We're operating under the official code of Georgia and the Georgia State Constitution. There, you happy? They just give you a bullshit answer. That's some bull. What do you just say, man? We operating under statutory, because, you know, ain't no such thing as a statutory jurisdiction. I hope y'all know that. When they say that, they say, I went to go to the law library and ask the clerk to give you the book on the rules of criminal procedure for a statutory jurisdiction. See what they tell you. They'll say some bullshit on the record. And when they say that bullshit on the record, that should be an automatic dismissal. That's why you want a transcript. That's the importance of having the court reporter in there to catch them on record saying some bullshit. You got to get that shit memorialized on paper. Now, it might mysteriously disappear out the record, because they will do that. So let's look and see what else he said. What did he say? He said, therefore, most likely, here's where the judge will probably start squirming and just avoid answering by advising you to get a licensed attorney for such legal advice. Okay, he tell you to get an attorney. This is what you say. Thank you, Your Honor, but I don't think that you'd be violating your oath of office if you did your duty under the Constitution. You see, I'm not seeking legal advice. What I'm attempting to know is your legal intent. And I have the right to represent myself in my own person without a licensed attorney. That's the 6th Amendment. I got a 6th Amendment right of self-representation. They might conduct some sort of colloquy in order to determine competency or something like that, but ain't nothing I'm showing you right here demonstrating that you're incompetent because you're asking questions. I have to know the jurisdiction that this court is operating under, because the rules of criminal procedure under the common law jurisdiction are very different from the rules under an admiralty jurisdiction. I need to know which jurisdiction you intend to try me under in order for me to proceed with this case. Now, the 6th Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to inform me. And I don't think you'd be violating your oath of office for doing so. So please, please answer the question. The judge might dismiss the case here, but will probably continue stalling. He or she is most likely to reprimand or threaten you for not getting a licensed attorney. I always tell them, they say, you really should get an attorney. I say, I'll take it under advisement. Right now, I need you to answer these questions. I need you to answer these questions. The judge will imply that only licensed attorneys have the information that you have to go and see a licensed attorney in order to get the question answered. When this happens, this is what you say. When they say you need a licensed attorney, because you're asking them, pursuant to the Sixth Amendment for the Constitution of the United States of America, you're demanding that he provide you the nature of the action, and he telling you to go get a licensed attorney. This is what you say. Thank you, Your Honor. Let the record of this court then show that I, John Henry Doe, the accused in this criminal action against me, have asked this court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of the action. Furthermore, let the record also show that this court intends to bring this criminal action against me under a secret jurisdiction that's known only to licensed attorneys. That's smacking somebody in the face. Do you see how this is where you get your information? This is how you get, man, you learn this book right here, man. You be ready for anything in court. You be ready for anything. And then you just start adding your knowledge on top of this. This is your base right here. You just get all this stuff around. So you got to have something to say in court. A lot of y'all don't know what to say in court. You don't know what to say. You got to rehearse your lines. They rehearse their lines. It's a stage play. They got rehearsed lines. That's when you take them off the script, they don't know what to do. They exercise a ministerial duty.